So a very good afternoon. So our judges are here. So before starting the final, I'd like to revise the rules for a clarification of the judges as well as for the participants also. The rules are already mentioned in the brochure. So you know in the final each team will get 30 minutes, 30 minutes. It means petitioner 30 minutes and respondent 30 minutes. So in the semi-final it was 25, now it has been extended to by 5 minutes to 30 minutes, okay? So on the 25th minute, a warning bell will be issued. And at the 30th minute, the final bell. The clerk will count your time exceeding the limit provided, and for each time that each minute you have exceeded, the marks will be negatively counted. So it will be deducted. So that is your time limit provided for the final. Next, you will have to put your phone in the switch off mode, not even in the airplane mode, and you will have to keep it up on the table. Next, you can submit your memorial, your submissions, written submissions, additional stuff, supplements, whatever you want to submit, you submit to the clerk. Directly approaching or handovering to the judges is restricted. Next, if any question is put in between the oral submissions, for that particular time, your time will be paused. As soon as you start your submission, your time will start. If there is any technical issue related to the mic that you are handling, or if there is any power cut, that time will also be stopped. It won't be counted. Immediately the issue is resolved and you resume your submission, the time will start again. So that's all from the rules and regulation part. Any doubt? Is it clear to everyone? Now I would like to hand over the session to the discussion of the judges. Your time starts now.
The council will be referring to the committee and asking when required, Your Lordship, with the due permission of the case. The council would also like to present the petition under Article 32 for pending public investigation. Yes, Your Lordship. Your Lordship, the council seeks permission to proceed with the facts of the case. Your Lordship, the state of Tumba is a state in the Republic of Jakarta. In this state, there are three prominent religions. The religions are Zohans, Tamils, and Sukmans. These three religions constitute around 95% of the population. And here, all these religions have customary practices associated with the nature, Your Lordship. Once they worship the nature one way or the other. One tribe worship the trees, specific tree called Tuara found in the region. The other tribe or the other religion worship the river called Tozosu found in that region. And another tribe worship all forms of rivers found in the nature, Your Lordship. These are the three prominent tribes. Here, once the modern democratic front, that is the ruling party in the state, Your Lordship, once they have come to power, they started implementing rapid industrialization, Your Lordship, with zero concern for sustainable development. This fact has been reiterated time and again by numerous scientific reports, Your Lordship. It is pertinent to note that even scientific report also said the same. And here, while implementing this rapid industrialization program, these programs had a huge toll on environment, Your Lordship. After the onset of COVID-20, which is a pandemic that affected all across the globe, this government imposed an arbitrary ban on the movement of people, Your Lordship. It includes two bans dated 22nd December 2021 and 23rd December 2021. It banned the movement in the region of Zosuk Mountains as well as in the region of origin of Tozosu River, Your Lordship. Your Lordship,
And here the petitioners humbly contends that these two government orders are found arbitrary and unreasonable in nature, Your Lordships, and for the same we have approached this honourable forum. If Your Lordships are satisfied with the facts of the case, the Council seeks permission to proceed with the issues in hand. Yes, Your Lordships, here in this present case, Your Lordship, here we have locus standi because yes, Your Lordships, the organization themselves are also part of the class of people, Your Lordships. Yes, Your Lordships, being a part of the class of population who are aggrieved as per the guidelines given in various cases such as MC Mehta, where the concept of public interest litigation was. Your Lordships, when the person themselves have locus standi, there is no need for specific authorization, Your Lordships. It is clearly stated in the proposition that the petitioners themselves are also aggrieved by these actions, Your Lordships. Yes, Your Lordships. Your Lordships, the authorization is not necessary, citing the case of Husainara Kadum versus State. One second. One second. Yes, sir. Your Lordships, Your Lordships, yes, Your Lordship. Much appreciated. Yes, Your Lordship. Much appreciated. Your Lordships, in the case of Janata Dal versus H.S. Chowdhury, it is stated that a person can even represent a class of people when they have collective objects. Your Lordships, the facts are silent in the regard. They have stated that even the petitioner are also aggrieved, but with regard to the authorization part, this particular Moot proposition is silent, Your Lordships. Janata Dal versus H.S. Chowdhury, Your Lordships. Yes, Your Lordships. Your Lordships. Since you have not presented the exact judgment copy, but you have much of this, Your Lordship. Sure. Your Lordship, the ratio that the petitioners are relying upon has been stated, Your Lordship. It has been stated that when a particular, not the Your Lordships, the Council again relies upon the relaxation of locus standi. Your Lordships, with regard to the Moot proposition, it has even stated certain incidents where even the people residing there have shown their form of opposition against, their form of rejection against the policies, Your Lordships. Even in 2015, similarly the government again tried to impose a scheme which was violative of their religious sentiments, Your Lordships. They tried to plant the tree which is against their religious sentiments. At that time, all the population, total 95% of the population stood against it. Your Lordships, Yes, Your Lordship, it is stated in the proposition last page that this organization is specifically formed by the people residing in that region, Your Lordship. It is clearly stated in the Moot proposition, Your Lordship. Much of it, Your Lordship. Council would like to move on with the issues in hand. The first issue deals with maintainability. The second issue deals with the validity of the two government orders passed dated 22nd and 23rd December 2021. The third issue deals with the right to clean environment as well as right to region. Lordships, I will be dealing with issue 1 and 2 in 15 minutes, and my co-counsel will be dealing with issue 3 in 15 minutes, reserving the extra time for rebuttal. Moving on in the first issue, that is maintenance, Your Lordships. Here the petitioners have approached this Honourable Court under Article 32, claiming this present petition to be a public interest litigation petition, Your Lordships. The Council would like to rely upon the PAL guidelines issued by the very Supreme Court, Your Lordships. It is found in flag number 1 of the complaint, Your Lordships. The Council requests you to much of it. The Council will be dealing with the further issues. It is in the arguments, Your Lordship. The Council will deal with this in the further arguments. Shall the Council continue, Your Lordship? Much of it. The Council requests Your Lordships to refer flag 1 of the complaint, Your Lordships. It is presented there. That big document, Your Lordships. Flag 1. We have marked it. Page number 44, flag 1, Your Lordships. Lordships, it states the PAL guidelines issued by the Supreme Court of India in 2017, Your Lordships. It states that in the 8th entry, Your Lordships, it clearly states that subject matter regarding environmental pollution, disturbance of ecological balance, maintenance of heritage and culture, forest and wildlife can be maintainable as a public interest litigation, Your Lordships. Drawing a parallel to the present case, here there is indeed environmental pollution, Your Lordships. It is clearly stated in the facts that the affluents from the canneries are directly mixing in the rivers found in the region, Your Lordship. That is the river of Dibrugarh. And there is ecological imbalance because the government has been promoting projects like mining and as well as hydroelectric projects, Your Lordship. These two are known to have a huge toll on the entire ecology, affecting the fishes living there, even the fauna, both fauna and flora living in the region, Your Lordship. As well as moving on to the next part, that is cultural and heritage. These customary practices are even found in the scriptures of the religion, Your Lordship. So it is indeed a custom that the religions have been found. And with regard to the forest and wildlife pollution, it is imperative that the state was even resorted to deforestation in order to build a 5-star hotel in a ecological zone, Your Lordship. Here, that zone is rich in medicinal values, and it is imperative that medicinal values are used for the purpose of saving lives, as the entire world is under the threat of COVID-19, Your Lordships. But here, instead of investing in research facility, the government is investing in a 5-star hotel, Your Lordships. The 5-star hotel has over 200 rooms, Your Lordships, so it will occupy a large amount of area in that dangerous zone, Your Lordships. To add upon, the essentials of PAL include substantial public interest, locus standi, and violation of fundamental rights, Your Lordships. Much of this, Your Lordship, it is clearly stated in the facts that the facts produced 2 scientific reports, Your Lordship. One was issued in the year 2010 by a body called World Scientists. It revealed that the increasing level of pollution in Tozosu River was solely due to the industrialization carried out by the state, Your Lordships. This scientific report is given in the proposition, Your Lordships. As well as there is another scientific report in the year 2021 by a body called Scientists for Traditional Healing, which concluded that industrialization is indeed taking away the medicinal values found in the region. The petitioner would like to lay reliance upon these 2 scientific reports, Your Lordships, which is produced by independent bodies. Much of the Your Lordships. Your Lordships. Proceeding with the substantial public interest, here arbitrary actions of the government prohibiting the movement of the locals. Instead of prohibiting the private actors operating in that region, they are prohibiting the locals who are residing in that region for thousands of years and carrying out their customary practices, which is present in their scriptures, Your Lordships. So it is violating of both their fundamental rights as well as hurts their religious sentiments, Your Lordships. And as I have already stated, these religions accounts for almost 95% of the population. So there is indeed substantial public interest in this present petition, Your Lordships. And as I have already stated, the petitioner has locus standing. And moving on to the derogation of fundamental rights, Your Lordships, in this present case, the right to equality under Article 14, right to assembly and right to movement under Article 19, Clause 1B and Clause 1D, right to clean environment, which is an inherent aspect of right to life and personal liberty under Article 21, as well as right to religion under Article 25 are violated, Your Lordships. The Council will be substantiating of the same in the Now, with respect to Article 14, the Council requests Your Lordships to refer flag 2 of the compendium, Your Lordships. That Council has stated the case of State of West Bengal versus Anganwadi Circle, Your Lordships. It is a landmark case which devised a twin test in order to ensure reasonability in any sort of classification, Your Lordships. The twin test includes intelligible differentia and rational nexus between the object and the action sought, Your Lordships. Here, in this present case, there is no intelligible difference, Your Lordships, because the government is authorizing private bodies who is carrying out mining activities, tanneries, and building even 5-star hotels to operate in the region, Your Lordships. But it is banning the local, innocent local publics who have been going there for thousands of years, Your Lordships. So yet there is no basis, and it indeed is an arbitrary decision, Your Lordships. So whenever there is arbitrariness, it strikes Article 14, Your Lordships. It is held in the case of Shreya Singhal versus Union of India also, Your Lordships. So that is indeed violation of Article 14, and there is no reasonable classification also, Your Lordships. Moving on to Article 19, Your Lordships, though Article 19 Clause 2 deals with the reasonable exceptions, reasonable restrictions, here it does not fall under any of the category, Your Lordships. The one possible reasonable restriction is the restriction of public order, Your Lordships. The Council would like to refer the case of Ram Manohar Logia versus State of UP, Your Lordships, where the court determined the scope of public order, Your Lordships. It determined that there must be a proximate relation between the object and the action, Your Lordships. Here there is no proximate relation because the government is claiming to protect the environment, but they are ultimately allowing the private bodies to still operate in the region, Your Lordships. They are only banning the innocent local residents from their movement, Your Lordships. So there is no reasonable restriction in this present case, Your Lordships. So Article 19 stands violated. Now moving on to Article 21, Your Lordships, in the landmark case of Menaka Gandhi versus Union of India, the Supreme Court has held that Article 21, that is right to life and personal liberty, can be restricted only by the procedure established by law, Your Lordships. And also in the case of K.S. Puttaswamy versus Union of India, which is found in flag 3 of the compendium, Your Lordships, the court has formulated a threefold test in order to legitimate the invasion into life and privacy, Your Lordships. Here, the threefold test is there must be a legislation, there must be sufficient need, and there must be proportionality, Your Lordships. The Council most humbly submits that all these three tests are not satisfactory in this present case. With regard to the valid legislation, Your Lordships, the management of forests comes under entry 70A of concurrent history, Your Lordships. So, as per Article 254, whenever there is an inconsistency between central law and state law, ultimately the central law prevails, Your Lordships. Here, in this subject matter, there already exists a central government law, Your Lordships. It is in form of Forest Conservation Act, Your Lordships. This will be substantiated by me in the following arguments, Your Lordships. Moving on to the next criteria, that is proportionality and reasonableness. Here, it is not proportional, Your Lordships, as the Council has already established. There is no rational nexus or proximate relation between the object and the action resorted to by the government, Your Lordships. Now, stating this, the Council would like to move on to Article 25, that is right to religion, Your Lordships. Your Lordships, even right to religion has its reasonable restrictions in the 25 Clause 1, which states that it can be restricted in the ground of public health, morality, and public order, Your Lordships. But here, it cannot restrict essential religious practices, Your Lordships. But in plethora of cases, the Supreme Court has devised certain tests in order to ensure whether the practice is an essential religious practice or not, Your Lordships. Here, the test is involved that much of it, Your Lordships. Much of it. The Council will get back to this question. Article 29 deals with the interest of minorities, Your Lordships. Here, nowhere it is stated that the religions present in the region are tribal or some sort of minorities, Your Lordships. In this present case, it rates it accounts to around 95%. The collective rights of individual is Your Lordships, while addressing the individual rights, the court has formulated a list of essential. Much obliged, Your Lordships. Much obliged, Your Lordships. But the Supreme Court in plethora of cases, like in the recent Sabrimala case, when Employers Association versus State of Kerala, it has formulated the test to ensure essential religious practices, Your Lordships. This test of essential religious practice considers the religious as a whole. It even considers the past customs of the religion, Your Lordships. So it laid down 3 essential tests, Your Lordships. Article 25 deals with the freedom of conscience, the profession, practice and propagation of religion, Your Lordships. Here, the religion of Zohans, Tamils and Sukhmins are under question, Your Lordships. So, Your Lordships, it is individual. Your Lordships, it is an individual right, ultimately refers to an individual, Your Lordships. But while specifically determining the essential religious practices, Your Lordships, here, what's your name? The council is arguing on the basis of Article 25, Your Lordships, because in the present Moot proposition, it has not stated with regard to minority, Your Lordships. The Moot proposition is silent in that regard, Your Lordships. So the council resorts to Article 25, where only in the test of essential religious practices, the religion is considered as a whole, Your Lordships. The religion is considered as a whole, even the religious scriptures which form the ultimate customs. Yes, Your Lordships. Your Lordships, co-counsel will be dealing with the same, Your Lordships. Your Lordships, in this present Moot proposition, it has much further. Here, the interest of the minorities is not in question, Your Lordships, because the 3 religions in question accounts to 95% of the population, Your Lordships, and with regard to with regard to tribal status, it is not notified. Lordships, here only 5% of the population is minority in this present case, Your Lordships. But the religious practices of that 5%. Your Lordships, any section of the citizen residing in the territory of India, any or thereof, having distinct language, scripts, or culture of its own, has the right to conserve the same, Your Lordships. Here it is clearly stated that the language spoken in that region is even spoken in the neighboring regions, neighboring countries, neighboring states, Your Lordships. So the matter of minority rights does not. Your Lordships, it includes language, scripts, and culture, Your Lordships. Yes, Your Lordships. Much obliged. Much obliged. Much obliged. Your Lordships, the right to indeed not, Your Lordships. But Here, much of it. After the council has argued for the four articles, Article 14, 19, 21 and 25 lordships, the council would like to move to the possible arguments as your lordships have already raised, why the council has not exhausted the alternative remedies, your lordships. For this, the council would like to place reliance upon the case of Whirlpool Corporation versus Registrar of Trademarks, Mumbai, your lordships. It is found in flag 4 of the compendium, your lordships. In flag 4 of the compendium, Whirlpool Corporation versus Registrar of Trademarks, Mumbai, your lordships. Here the Supreme Court, no, your lordships, the council is putting forth this argument. Your lordships, honorable lordships raised the question in the regard, your lordships. Honorable lordship issued a question in the regard, your lordships. Yes, your lordships. Yes, your lordships. Here, Supreme Court gave an exception for the condition of bar due to existence of alternative remedies, your lordships. Supreme Court gave four major criteria in which situations the aggrieved party can directly approach the Supreme Court, your lordships. The four criteria involved when there is violation of fundamental rights, when there is violation of principle of natural justice, when any order or proceedings are done without jurisdiction, or when violation of the act is challenged, your lordships. Here, in this present case, indeed there is violation of fundamental rights, your lordships. So the council has directly approached the Supreme Court under Article 32 instead of resorting to a High Court under Article 226, your lordships. Yes, your lordships. In flag 4 of the compendium. In flag 4 of the compendium. Your lordships, in this case, your lordships, alternative remedy cannot be a bar in this situation, your lordships. Incident takes place in a specific state, your lordships, but when the issue is decided by the Supreme Court, it can be a valid precedent all across the country as per Article 142 of the Constitution, your lordships. It is also a ground why the petitioners have approached to the Supreme Court, your lordships. So it can be valid precedent to many other circumstances, many other incidents. Your lordships, violated in this present case, your lordships. Your lordships, here Article 19 deals with the aspect of freedom of speech, occupation, expression and those forms, your lordships, whereas Article 21 was initially just a right to life, your lordships. After the Maneka Gandhi case, it was expanded into right to life and personal liberty, where the first term personal liberty not only means mere human existence, your lordships, it also has human. Your lordships, the scope of freedom under Article 19 is much wider than the scope of personal liberty in Article 21, your lordships. What is found very essential and fundamental. The council does not have any citation. Much of it. The judgment of both of them are kept in the same pedestal, your lordships. It forms the golden triangle of Article 14, 19. Your lordships, yes, your lordships. The council is not arguing about the status of the liberty and freedom, your lordships. It is arguing about the scope of liberty and freedom, your lordships. The status of Articles 14, 19 and 21 are all one and the same. It is given in the case of Maneka Gandhi versus Union of India, forming the golden triangle rule, your lordships. So, it is indeed liberty and freedom are in the same ground, your lordships. Council seeks permission to proceed with issue 2, that is validity of the two government orders, your lordships. Here, in the case of Namit Sharma versus Union of India, the scope to challenge any piece of legislation is given under three main grounds, your lordships. That is, that can be legislative incompetency, violation of fundamental rights, as well as reasonableness, your lordships. Now proceeding with the legislative incompetence, Your Lordships, the Council requests Your Lordships to refer flag 5 of the company, Your Lordships. It states Section 2 of Forest Conservation Act of 1980, Your Lordships. In that Section 2, it clearly states that any forest land can be used for non-forest purposes only after prior approval of central government, Your Lordships. So, as I have already stated, management of forest comes under concurrent list, entry 17A of the concurrent list, Your Lordships. So, whenever there is inconsistency between state and central law, the central law ultimately prevails, Your Lordships. So, here, the state government has no locus to legislate upon the subject, Your Lordships. So, the Council humbly submits that the Parent Act passed in 2021 itself is not valid and malpractice of the Constitution, Your Lordships. Now, proceeding further, as the Council has already elaborated that there is derogation of fundamental rights under 4 articles, the Council would like to skip the part and move on to the ground of reasonableness, Your Lordships. Lordships, for the ground of reasonableness, as per the Wegner-Sperry principle of reasonableness, which is even used in the landmark case Kutteswamy vs. Union of India case law, Your Lordships. Here, any piece of legislation can be struck down under 3 grounds, Your Lordships. First, it must be illegal. Second, it must be irrational. And third, there must be procedural infirmities, Your Lordships. But here, in this present case, the act of restricting the locals residing in that place, instead of the private operators operating in that region, is unreasonable, Your Lordships. Because the pollution is ultimately caused by the private actors who are operating in that region solely for commercial purposes, Your Lordships. It is inherent in the proposition that the government is promoting activities such as opening of tanneries, industries, hydroelectric plants in the forest itself, Your Lordships. So, it is the act of the private bodies that is polluting the environment, Your Lordships. But the government is imposing the ban on local residents, still the private bodies are allowed to operate, Your Lordships. So, it is the primary reason for the pollution. So, this certain restriction is arbitrary and unreasonable in nature, Your Lordships. Unreasonable, Your Lordships. As the Council has already stated, the 2 reports, Your Lordships, 2010 report by the body called World Scientist, as well as 2021 report of the body called Scientists for Traditional Healing. Both of them has concluded that this rapid industrialization resorted to by the state is the ultimate source of pollution in the region, Your Lordships. So, instead of banning the industries operating in that region, banning innocent residents and innocent peoples living in that area is solely unreasonable, Your Lordships. So, the Council would humbly like to conclude that both the orders passed by the government of Kumba dated 22nd December 2021 and 23rd December 2021 are unreasonable and arbitrary in nature, Your Lordships. Lordships, if Your Lordships have no further queries, the Council would like to leave the podium for the co-council to argue upon issue 3, Your Lordships. Much obliged, Lordships.
The Council seeks permission to address the bench. The Council is dealing with the third issue, which is whether the one-sided and unscrupulous path of industrial development followed by the state government is resulting in the violation of the basic right to environment and right to religion of many persons in Kumba. The Council would like to deal with this issue with regards to both the rights in question, the right to environment and the right to religion. With regards to the first sub-issue, the Council seeks to establish that there has been a clear violation of the fundamental right of clean environment. The Council would like to bring the court's attention to the case of MC Mehta vs. Union of India, which is the 1987 case, the Oleum gas leak case, where the Supreme Court had implicitly held that the right to clean environment is a part and parcel of Article 21. In the case of Chetri of Padush and Mukti Sandesh, with the state of Uttar Pradesh and others, the court had explicitly mentioned the same as well. And this has been reiterated in a plethora of cases following the same. The Council first submits that the state government is clearly destroying the environment. The actions that have amounted to being environmentally dangerous are opening of tanneries and other chemical factories on the banks of many rivers in Kumba. Council would rely on the Vellore tanneries case, which had a similar issue, that tanneries were opened and the effluents being released from those factories were not being treated, and the industries which were responsible for the same were caught and were asked to pay a fine based on the polluter-based principle according to sustainable development goals. Yes, sir. Yes, sir. Council's contention is that the state government has been negligent where it should have been following the principle of sustainable development goals. With regards to their policy, they have only focused on development, leading to the destruction of environment. The state government has Your Lordship, with regards to the opening of industries, there is nothing in specific mentioned. The Council would assume it is a policy matter, but because of the policy matter, the right is being violated. In the present scenario, the Moot proposal is silent on whether the state has given a notification calling for these industries or not. Yes, indeed, yes, sir. Your Lordship. Your Lordship, we are challenging the fact that there is an order which is restricting people from accessing these regions, while that same area is being given access to a private company for construction of a hotel. Your Lordship. Additionally, the 2010 survey also showed that the increasing level of pollution has prevented these people from carrying out their religious practices as well. The Council would like to refer to the public trust doctrine which was originated by the Supreme Court in the case of MC Mehta vs. Kamal Nath. Your Lordship, we have mentioned this in compendium page 149, flags 6 and 7. In this case, a large area of the origin of the river Bias, which is part of a protected forest, had been given on a lease purely for commercial purposes to motels. This lease was given to a private company by the name of Span Motels Private Limited, in which the family of the former Minister of Environmental Forests, Mr. Kamal Nath, had a direct link to. This is identical to the present case scenario. What the court held in that case is that the public trust doctrine primarily relies on the principle that certain resources like air, sea, waters and the forest have such great importance to the people as a whole that it would be unjustified to make them a subject of private ownership. The said resources being a gift of nature should be made freely available to everyone irrespective of their stature in life. This judgment also followed the footsteps of the American courts, which had expanded the public trust doctrine for all ecologically important lands, which include water, wetlands or riparian forests as well. And in the present case, it is a riparian forest. As evident from the MC Mehta vs. Kamal Nath case, the court has indeed interpreted this doctrine to be a part of our legal system as well, Your Honor. By restricting the common public from accessing these resources and exclusively handing them out to a private contractor for the construction of a 5-star hotel in the only part of the state that has yet been untouched by the pollution because of the actions of the state government has clearly violated the right to environment of the people, Your Lordship. The Council would also move to the next limb of the arguments, which is that they have ignored the principle of sustainable development goals. In our compendium, page 107, flag 8, we have listed down the principle of sustainable development goals as it was given in the case of Vellore Citizens Welfare Forum versus Union of India. In this case, the precautionary principle was interpreted to be part of our legal system as well. There are 3 methods. First is environmental measures, where the state must anticipate, prevent and attack the causes of environmental degradation. First, there was a report published. The state did not take any measures as soon as the report was out. And for preventing and attacking the causes of an environmental degradation, all the measures which were taken by the state following that, they, as it was given in the Moot proposition, the level of pollution was not controlled, Your Lordship. Secondly, when there is a threat of serious and irreversible damages, lack of scientific certainty should not be used as a reason for postponing measures to prevent environmental degradation. In the present case, there are scientific reports to prove environment is being degraded. Regardless of that, the state did continue industrializing and did continue polluting. Finally, there is a document of environment impact assessment, Your Lordship. Yes, Your Lordship. With regard to the present case, we are arguing that the sustainable development goals were not followed. Yes, sir. Yes, sir. In the present case, no, sir. Your Lordship, there. In the present case, there is no such report, Your Lordship. With regards to the source. Yes, Your Lordship. Yes, Your Lordship. Your Lordship, we had not approached the Green Tribunal as it was stated by my co-counsel. The existence of an alternate remedy does not bar us from approaching the Supreme Court itself, Your Lordship. And we believe that. Indeed not, Your Lordship. The reason we have approached the Supreme Court is because we believe the industry is. The council is not aware of the same, Your Lordship. With regards to the particular one, we have gone with the Sustainable Development Goals. We have also mentioned the Biodiversity Act, Your Lordship, the Convention on Biological Diversity, and how it has not been followed in the present case scenario. Convention on Biological Diversity, Rio de Janeiro, 1992. Your Lordship, the National Green Tribunal, there are cases. Indeed not, Your Lordship. The reason we are still. Much of Your Lordship. The reason. Much of Your Lordship. The reason we haven't approached the National Green Tribunal is because they. Not, Your Lordship. We believe the contentions we have made are sufficient with regards to the lights of the present case, Your Lordship. Need not, Your Lordship, if the High Court this is what has been said by a superior court, and it has to be it has been given already, it has to be followed in the following. Under 142, it acts as a law, Your Lordship. Discretion is when the judge is given a special authority to make their own decision, taking different circumstances in the issue. Yes, Your Lordship. They are bound by the. Really not, Your Lordship. Indeed not, Your Lordship. I could cite an example for the same as well. For example, in this Beirut Tannery case itself, Sustainable Development Goals was held to be a fundamental part. However, National Green Tribunal gave a judgment later on in 2017 where they held that development and protection of environment must go hand in hand as well, Your Lordship. So, if the lower court is to come up with an innovative situation, it can be accepted. Innovative judgment, it can be accepted. Your Lordship? Okay, much obliged, Your Lordship. The Council would like to move to the next sub-issue, which is that there is also a violation to the right to religion, Your Lordship. Firstly, the Council submits that in pursuit of industrialization, the state has disregarded the right to religion completely. The orders restraining movement themselves are violative of the right to practice religion of the three sets of people. And additionally, the state government has been implementing policies such as artificial planting of the tree which is considered sacred by them to discourage the Tamils from using the tree. And this has been happening for a while, and it based on what has happened recently, which is extending the land, giving the contract of the land to a private constructor for construction of a hotel, it is evident that the motive in planting of the trees might have been to discourage people from accessing the hill so they could sell it off easier. These people have been practicing all these practices for a time immemorial, and they have been preserving the forest for so long as well. The Council submits that the practices carried out will amount to essential religious practices, and these three groups worship the tree, the rivers, and clear out the main river of the land. All these points toward the ecosystem acting as a sacred grove, such as the one in the Kasi and the Jaintia hills. A sacred grove is where people living worship the ecosystem and in turn end up protecting it. Ever since the state government disregarded this entire concept and started industrializing is when the forest quality started deteriorating, the rivers started getting polluted, and all these pollutions started happening. The Council submits that the action of state do not fall within the exceptions given to Article 25 as well, which is that subject to public order primarily ascertained with references to the doctrines of that religion itself. And it also stated that if the tenets of any religious sect prescribed periodical ceremonies should be performed in a certain way of certain periods of that year, then that would also be amounting to an essential religious practice. This is a ritual which is being performed in the same time over and over. It has been followed for time immemorial, and it is actually a method of conserving the environment and protecting the public health of the people. The test of essential religious practice has also been broken down, which is for the test of scriptures in the Triple Talaq case, the Shayara Banu's Union of India. It was held that when dealing with religious matters, reliance must be based on the religious text to test whether it includes the said religious practice as an essential practice or not. In the present case, it is given the proposition, it is included in the religious tenets. Next is the test of fundamental change in religion. The entire characteristic of this religion is to worship the tree, the river, and the clay of the river. And it was said that religion is something that it is based on a system of belief or doctrine which are regarded by those who practice it as conducive to their spiritual well-being. The entire religion is based on the principle of worshipping these things, and the state government restricting it is clearly violating the essential religious practice. Thirdly, it is a test for genuineness of belief. Any belief that has been preached and genuinely followed by any follower can be said to qualify as an essential part, provided it has been done for a long time without any malicious intent, and it can be correlated with the present case as well, Your Lordship. The Council would like to say that the exception would also not, the exception of health would not be applicable in the present scenario, because even if the state government wanted to restrict them based on the ground of health, it started in 2021, Your Lordship. Up until 2024, the restriction has still been prolonged, and no explanation has been given about the progress of the research, and instead they have started constructing the 5-star hotel in the only part of the state that is not yet polluted. Additionally, this was a sacred route, and the practices these people were carrying were in a way protecting it. By restricting them, the state is already causing degradation to the forest. The government also gave, the council would also like to submit that the action of the state government violated provisions of the National Biodiversity Act, which was implemented to ratify the Convention on Biological Diversity of 1992. In companion page 29, flag 11, we have given provisions which are contrary to the actions of the state. The Convention on Biological Diversity's main goal was, one of the main goals of the CBD was to preserve traditional knowledge. And to make sure the research is done on traditional knowledge, it is to be, when the benefit arising out of such research is to be shared equally. Sections 25 clause 2 clause A talks about the joint ownership of the intellectual property rights of the research being done. The state government has completely blocked these people from going to this area. It is their traditional knowledge because they have been practicing it for such a long period of time. And section 25 clause 2 clause C, it talks about the location of production, research and development to facilitate better living standards to the benefit claimers. The state government has already polluted basically the entirety of the state. Now it has gone to the origin of the river, the place where these guys worship, and it has restricted the access to that also, and it has started deforestation for construction of a hotel. Taking all this into account, the council submits that it violates the provisions of the National Biodiversity Act as well. If your lordships have no further questions, may the council move on to the prayer. Much obliged, your lordship. Therefore, in the lights of issues raised, arguments advanced and authority cited, it is most humbly and respectfully prayed that this honourable court may be pleased to adjudge and declare that the present petition is maintainable, the orders passed by the state government are unreasonable and arbitrary, the right to environment and the right to religion of people in Tumba have been violated, and or pass any other order or orders as this honourable court deems fit and proper, the circumstances of the given case, and in the light of justice, equity and good conscience. And for this act of kindness, the council for petitioners will be duty bound and forever. Much obliged.
The Council seeks permission to address the bench collectively as your Lordships and individually as your Lordship. Much obliged, Your Lordship. I am the Speaker 1 and I, along with my Speaker, will be representing the respondent, that is the state of Tumba in the current case. Your Lordship, the respondent side will be making submissions on 3 major issues today. This Council shall be addressing the first and the second submission, and my co-counsel shall be addressing the third submission. Your Lordship, we shall be taking 14 minutes each of this Honourable Supreme Court's time, and we reserve 2 minutes for rebuttals. If Your Lordship is well versed with the statement of facts, the Council seeks permission to proceed with the arguments at once. Much obliged, Your Lordship. Your Lordship, the respondent believes that the petitioner has clearly failed to establish the maintainability of this current petition before this Honourable Supreme Court. And for that very reason, we request this Honourable Supreme Court to not entertain the same. Your Lordship, Article 32 of the Constitution provides that for the enforcement of fundamental rights. But Your Lordship, the respondent contends that the PIL which has been filed by the petitioner in this situation does not hold any standing because there is no clear violation of the fundamental rights that the petitioner alleges. Moreover, Your Lordships, the respondent strongly believes that there has been no clear violation by the government of any of the fundamental rights that are laid down by the petitioner. No, Your Lordship, there is not at all absolute. No, Your Lordship, there is no clear, direct, overt or tangible kind of violation. No, Your Lordship, there is no violation by the government side. Your Lordship, as the petitioner... Yes, Your Lordship, absolutely no violation, and also as the petitioner has been Yes, Your Lordship. Your Lordship, Article 32 of the Constitution clearly lays down that you can approach this Honourable Supreme Court when there has been a clear violation to your fundamental rights. Yes, Your Lord. Yes, Your Lordship, but the government confirmly believes that there has been no violation to these fundamental rights as it has been alleged by the petitioner. Yes. Yes. Yes, Your Lordship. Your Lordship, but they haven't exhausted the alternative remedy that has been provided to them under Article 227, which says that they can approach the High Court. And they can approach the High Court, but in order to approach the Supreme Court directly for a PIL, they have to take into consideration that there are 226, Your Lordship. Your Lordship, under Article 226, and to continue what I was saying under Article 32, they have to establish that there was clear violation to the fundamental right. Even, Your Lordship, I would like to cite the case of Fertilizer Corp Kamwood Union versus Union of India, a 1981 case. It is present on our memorial, page number 2, which says that it is an essential requirement of Article 32. It is a sine qua non, meaning it is an indispensable, necessary and essential condition that there has to be violation of fundamental rights. The petitioner today is alleging that there is violation of fundamental rights. But Your Lordship, I asked how. They haven't yet proved us on what grounds there has been a violation to these fundamental rights. Moving on with my further arguments, Your Lordship, our stance is clear. We are the government of the people. Yeah. Yes, Your Lordship. Yes, Your Lordship. Yes, Your Lordship, that is what I will be dealing in my further submissions. Is that so? Yes, thank much obliged, Your Lordship. Your Lordship, our stance is clear. The petitioner claims lack of substance, and we, being the government, are working only for a vision of progress. There is no concrete violation of the fundamental rights, and for that very reason, the respondent urges this Honourable Supreme Court to not entertain this petition under the jurisdiction of Article 32. With that, I conclude my first issue, and now I request to proceed with the second issue if the Lordships are satisfied. Much obliged, Your Lordship. Your Lordship, the second issue, which says that the orders passed by the respondent, that is the government, on the movement of these people is clearly reasonable, and they are reasonable, and they are not at all arbitrary at any given point of time. Further, they do not even compromise any of the fundamental rights of these citizens. Your Lordship, we being the government are doing nothing but providing the best to the people. Your Lordship, we are keeping in mind 3 essential things at this moment. First is the safety of the people. The second is the security, and third is the well-being. Your Lordship, our decisions as the government were well rooted in reason. We have provided proper reasons ensure safety, security and overall well-being of the people. Moreover, Your Lordship, for that very reason, I implore you to these 4 sub-issues that will be established how the government has worked in a bona fide manner by providing security, health as well as well-being to these people. The first is the maintenance of peace and order. Your Lordship, I would request you to move to the just one. Yes, I'm so sorry, Your Lordship. Your Lordship, I request you to move on to the page or to the fact sheet which clearly states that in order to maintain public peace and order, and Your Lordship, I would like to highlight that there is a situation where the people of the Sukmans are gathered at the Thuzosu river in order to protect the pristine galleries. Your Lordship, they have clearly mentioned that these people are against the ideologies of the MDF and they do not believe in them. Moreover, Your Lordship, if the government has made known that these incited scrupulous followers have gathered at the Thuzosu river in order to protect the pristine lilies. Your Lordship, it is a case where the government had to take precautionary measures in hand. Moreover, Your Lordship, they cannot sit back with their hands folded. The same was also laid down in the case of Babunath Patel versus State of Maharashtra, where it was held that in order to maintain public order, there has to be steps that have to be taken well in advance. These are anticipatory measures which the government had undertaken. And with that, the first issue, I would like to summarize the first sub-issue. Moving on with the second sub-issue, which is the presence of restrictions provided on the fundamental rights. Your Lordship, I would like to make this clear that these fundamental rights